Good afternoon, everybody. This is the Josephine County Board of County Commissioners for a continued land use hearing. Today is November the 19th, 2025, and it is 2 p.m. This is a continuation of the meeting of October the 13th, 2025, and this is a request for an appeal for the planning director's decision to approve a type 2 home occupation to allow boat manufacturing and fabrication business in a residential neighborhood. I will remind everybody that the board did do an on-site visit this morning at about 10 o'clock, and we were there for, I believe, approximately half an hour. This continuation will start with the applicant's oral rebuttal, and the applicant, I will remind everybody, is the protestant in this case. We'll give you 10 minutes and give you an opportunity to speak to this board. Who would like to speak on behalf of the applicant? Okay, just come on up to the lectern. No reason to be nervous or anything. We're all here amongst mostly friends. So the procedure says that we'll give you 10 minutes. If for whatever reason you need maybe a little bit more, we're okay with that. But if you need less, that's fine too. So no stress. We will put up a counter up on the screen there, but don't let it make you nervous.
More nervous?
No, don't let it make you nervous.
Commissioners, I would like to say thank you. Or actually, I need to introduce myself. I apologize. Good afternoon, Commissioners. My name is Andy McCarty and my husband, Grant McCarty. We are here as the applicants in this hearing. We reside at 160 Devon Drive. All right, Commissioners, thank you again. Thank you for your time and coming out to the properties this morning. I know on behalf of our neighbors, we greatly appreciate that. This is the rebuttal portion, and so I have some points to have as a rebuttal from part one, if that's what I should call that.
Sure.
Part one of the hearing. Okay. Mr. Williams had said that we don't have adequate drainage to accommodate the water runoff before it flooded our back driveway. Again, we've never had any flooding issues prior to the shop construction and the movement of the creek to where it no longer aligns with the original flow from property to property. According to Frey Paving, Cameron Frey, we had asked him to come out and take a look at our property, and he wrote a letter. He was tasked with addressing a drainage issue at the McCarty residence located at 160 Devon Drive, where a neighboring property owner constructed a shop at the lowest elevation point of their land. This construction altered the natural water flow from multiple uphill properties, resulting in significant erosion on the client's property. Specifically, the stream was redirected 25 feet to the west, causing water to accumulate due to the stream no longer at the property's lowest point. To resolve this issue, implementation of erosion control measures is recommended to redirect the water flow effectively and stabilize the soil, thereby preventing further erosion and protecting the client's property. In section 19.92030, general definition, page 5, in our binders, there are 16 requirements out of 22 requirements that are clearly not met for the home occupation approval. That is a 64%, does not meet county standards. Section A1 does not comply. Metal fabrication does make a lot of noise. It is not compatible with a residential cul-de-sac. You should have the right to expect a degree of quiet when you live at the end of a private road. Devon Drive is not a thorough road. Even without the generator, metal fabrication creates excessive noise, banging, clanging, and jarring sounds when metal is pounded over and over into its shape. Tossing scraps into the recycle bin is loud. Commercial compressors, the commercial specialty tools, it all makes excessive noise, which is why commercial fabrication manufacturing companies are not located in private residential neighborhoods. What about the aluminum shavings that fall off the boats or trailers that have gone across the driveway or in the cul-de-sac? We actually stepped on aluminum shavings today when we were on the property. How does that accumulation affect our watershed? It's actually an environmental concern, according to the EPA fact sheet, source July 2017. Regardless, offensive noise, dust, glare, like from welding, is detectable to the normal sensory perception at the property line, as you witnessed today. And that is something that is not, Mr. Williams is not going to be able to mitigate those criteria. Section A, number 2, had Mr. Williams been honest with the planning department, he would not have been allowed a development permit to build that 50 by 70 shop. County planning permit says not for commercial activities because we are in a private residential zone. Again, Mr. Williams stated before he purchased the property and immediately after purchasing the property that he was running a boat manufacturing business in the backyard. He would rent it to himself and build boats around the clock. And that was posted online July 1 of 23. Mr. Williams' DEQ checklist is not accurate. There are hazardous materials stored outside. All parking is not done on site. There's just clearly not enough room. Again, Mr. Williams has no permit, yet he runs this business without any consequences from Josephine County Building and Safety, meaning that he does not have a final approval. Yet his boat shop has been registered with the state of Oregon since January of 22 at 1767 Devon. When we look at the rest of the criterias, page 7, numbers 8 through 13, we're not sure what that tower of wood pallets is, but it does look unsightly and a bit dangerous. There's no solid fencing. Hours of operation are well before 8 a.m. and well after 5 p.m., and certainly working on the weekends, as submitted evidence in this last time period. It mentions that inside storage of boats and trailers, they all can't be stored inside. And Mr. Williams, by his own admission, page 85, criteria B, number 2, stated in his own handwriting that any adverse effects from his business cannot be reasonably mitigated. Mr. Williams also stated in the first hearing that he was an open book about everything. Let them, the neighbors, know what I planned to do there. Did our due diligence, talk to the county officers. I didn't want to step into this pouring out money and not have it approved. Driveway access to the boat manufacturing shop. We all walked down it today. It states the driveway should be 12 feet wide for residential. Exhibit D, page 6, from Mr. Williams. Exhibits shows Mr. Williams' Suburban parked at the widest part of the driveway. Suburbans are approximately 6.7 feet wide, and does that look like there's another 6 feet available? Not if you're trying to clear the roof overhang. Cars and trucks will start to back up, etc. Additionally, the DEQ septic map for 176 Devon shows the lateral lines are 90, 90, 80, and 40 feet respectively. The tank is out to the side of the house, which we walked by, walking down the driveway. Then those lines are lengthwise and not horizontal, as shown on Mr. Williams' map, Exhibit B, page 10. The repair area is beyond the leach lines. His new driveway that he created in order to access the new shop is over part of his own leach lines and his own repair area. I don't know how this could meet driveway requirements, not to mention that trucks with trailers and boats, if they make the turn after hitting our own post, must back down the driveway. There's simply not enough room on this 1 acre parcel for 2 septic drain fields, 2 septic repair areas, a house, a 50 by 70 building, and then you add all the proper requirements for a boat manufacturing home occupation business without seriously and negatively impacting the neighborhood. Regarding the permit approvals for the boat manufacturing shop, it was only allowable to be a private shop garage, not intended for commercial activities. You can see how things fall through the cracks, because if it's intended to be a private residential garage with no electrical or sewer or a driveway, then why do you need to get approval from DEQ, Public Works? I mean, what about OSHA? I mean, are there any inspections such as electrical for those things? And there was electrical in the garage shop. So is there a permit for that? What about safety for employees? No water. I will say that porta potty on the side, we know that that was purchased and delivered October of 2024. And no one in the neighborhood will forget that day because actually the porta potty delivery guy couldn't navigate the driveway or the cul-de-sac and wiped out all the mailboxes in front of the Conrad's property. That was never acknowledged by Mr. Williams. Mike and Linda Tedson were the ones who got our mailboxes replaced and put back on the mailbox stand for all of us. What about an eye wash station? No fire safety plan. Mr. Williams has drawn proposed fencing on Exhibit A, page 16. Any type of solid fencing should be installed on his own property, actually tall enough to provide coverage to prevent the glare, dust, and erosion from further violation of our private property rights. But what kind of fencing does that even look like? I mean, he's already built up the property 6-8 feet. We feel that that's another condition that would not be enforceable, as this entire process has been for the last 2 years. Mr. Williams was not truthful when obtaining his permit, his development permit for the building, but he claims that he has performed his due diligence before purchasing the property. This shows his intent to manipulate the process because he knows he cannot meet the criteria or standards.
Go ahead if you're just about to finish up.
My sentence?
Yeah, you bet.
For this home occupation at this location. Thank you for visiting our properties today.
All right, thank you. Next up, we'll have the opponent. And typically we give 5 minutes to the opponent and then any other person that wants to speak to that. But if you would like, we could give you the whole 10 minutes or however you want to break it up, I think would be fair. Okay. We'll give you 10 minutes on the timer. If you're done early, that's fine.
Perfect. To regards of the porta potty.
For the record, could you give us your name?
Oh, I'm sorry. My name's Douglas Williams, property owner of 176 Devon Drive. For the porta potty incident, that was a complete accident of the driver trying to back up his truck because they are pretty wide. That was fixed the same day by Best Portable Potties Toilet Company. And I don't understand why she would try to lie about that. It was fixed the same day by that company, and I got documentation of everything that happened. So that being said, I'll carry on to my speech. Like I said, my name's Douglas Williams, 176 Devon Drive. The use of the property, I have gone the right avenues to build and get approval of this home occupation. I've invested my money to build a dream I've had for a long time. Doing this has enhanced neighboring properties as well. Investing in a property does not appreciate neighboring properties whatsoever. Per county planning, every house on Devon Drive could build the exact same size shop as mine based on land use regulations. My business does not create excessive traffic nor do I have any signage to draw attention to my property. I just don't understand. A neighbor could tell me what I can and can't do on my own property while videotaping everything that I do in my own backyard. I was threatened by Mr. McCarty once with physical violence, stating he wanted to punch me prior to building the shop. This occurred in front of 2 employees and a truck driver at the time of delivery. I've been harassed by Mike Tedson a few times prior to building my shop in my backyard on my own property, stating I couldn't build a shop, that I am lying about my building permits issues from the county planning. It's the procedures. I could not lie about the procedures. I've had vandalism done to my shop by Mr. Tedson's family by throwing rocks at the metal siding while living in a tent on Mr. Tedson's property near that trailer we saw today. I did not press charges because I'm a fair man, always going above and beyond in a godly manner. Love your neighbors, and I have done just that. They have taken advantage of my grace. The McCartys have deliveries from Ferguson's Plumbing to their home on 176 as they run a plumbing business there and receive plumbing supplies from a commercial truck company to their yard. I have photos of the plumbing supplies littered throughout their property, documented pictures, dates, and all that good stuff, which they have done extensive cleaning prior to this meeting. They surely fall under the same type 2 home occupation as I do, but they have not filed for any permits. They have been cleaning up their land since the approval of the BCC coming out to property for inspection. Mr. Tetson built an accessory shed on the side of his 2-car garage shop to run a business out of as well, without any home building permits to do so. With this being said, why do the fingers always point to me while I'm the one going through the right avenues the legal way? As a company owner, I have documentation of times, dates worked on employees' time cards I have brought with me today. Stacks of 24, 23, all digitally punched out, and there's no way I can make up all this stuff. It's all documented. And we've never worked more than 40 hours. It's all in there. Never more than 40 hours a week, no more than 80 hours a pay period. As a company owner, I have documented times and works on the time cards I brought today. The McCartys have a camera pointed right at my shop and my swimming pool and have invaded my privacy, family's privacy since day one. Any motion that sets off that camera, they claim that I'm working that day, which is totally false, especially on Father's Day, which I don't know why she would incorporate that in her speech and evidence. We are supposed to be truthful in all of this, and it's totally far from it. Why is Andy so concerned with my leach field at 176 Devon Drive and my repair area? It is mine to be concerned with, and they have their leach lines running from their home all the way across their property to my backyard. They have a circular driveway that runs most of their backyard, which Grant drives his work truck and Andy drives her car 3 to 4 times a day, that's just leaving. So it'd be a total of like maybe 6 times that they're driving over it with their own personal cars. Plus their weekly trash truck. They have a special service that a trash truck comes and picks up their trash weekly, and it's a big dump truck. And UPS deliveries driving over their septic line below the gravel road. Again, complaining about my own leach lines while doing the very same thing to theirs. Andy has used her real estate expertise to try to bully me in every which way she can, but to date, everything has been unfounded. Her expert witnesses, Kendon Lee and Chelsea Burchett, both stated in the first meeting that they have not personally been to either property nor heard the generator before testifying on her behalf. I'd also like to point out that if the McCartys would grant Power Company easement access from the transformer on 118 Devon Drive from approximately 25 feet to trench underground power to my property, the complaints of the generator would be mitigated. They have leach lines on my property, but refuse to allow power easement from their property onto their property. The McCartys have devalued my property with their leach field in my backyard, trying to say they have the right to claim over half my property for their use. Why would I have purchased this property if half of it was unusable to me? I have left my property as is since the date of our first BCC meeting. As you can see, the state in which I live in and conduct business. I am being truthful about everything. In conclusion, I am an honest guy trying to live the American dream, raising 4 kids while working from home. I'll always pray for healing in our neighborhood and for all of us to be kind to each other. We all want one thing at the end of the day, and is to be happy and content with our neighbors. Thank you for your time and reflecting on the situation.
Okay, thank you. Next up, we'll go for a summation. This will be 5 minutes for you to speak in summation, and then we'll also give you 5 minutes.
Okay. Thank you. Andy McCarty, resident at 160 Devon Drive. You have heard real estate expert testimony to the decrease in property values and medical expert testimony validating detriment to exposure to excessive noise. You have heard from several concerned neighbors, and you have in hand additional testimonies that were submitted in writing. May I ask, did you know that there are 8 boat shops in Grants Pass and that they are all located in industrial or commercial zoned areas where you would naturally expect to hear that type of commercial noise and be exposed to that type of environment? Mr. Williams of D-Tech Boats, he's actually a very established boat business, and it was previously located in an industrial complex for at least 5 years, where it should be, before purchasing the home at 176 Devon Drive and deciding to relocate into our small residential neighborhood. Mr. Williams has never denied that he lied on that application for the developmental permit. He knew the permit said no commercial activities, and with the helps of his friends in building safety, continued to manipulate the system to get what he wanted. He has bragged on Facebook that he was building a boat shop. He admitted in the first hearing that he told everyone what he was doing, and he has never denied his personal relationship with Frank Weregard. Based on that alone, home occupation should be denied. James Black was clear in our first meeting when he was reading the rules with the PowerPoint that to ensure the proposed business does not have negative effects which would exceed residential character, right, and enjoyment of the neighborhood. When you have 14 out of 16 neighbors complain, what does that say? It should be known that we do want Mr. Williams and D-Tech Boats to be successful and be able to provide for his family. Mr. Williams just needs to have an appropriate location for his business, that's all, such as his previous location on Redwood Avenue, where he was established at an industrial zone space since 2018. And this is not personal. We chose this neighborhood because of the privacy and country feeling. The CCNRs gave us an assurance that we could expect a peaceful setting to come home to. That little bundle of rights of home ownership should not be allowed to be manipulated by a few at the expense of others. We all have the right to equally enjoy our bundle of rights of home ownership. Martin Luther King said, "Injustice anywhere is a threat to justice everywhere." It's just not acceptable, or doesn't seem right, that one person can disrupt an entire neighborhood, use his personal influence with friends in the building department, and significantly reduce property values just to further his own gain and benefit at the expense of others. This commercial business has negatively impacted the aesthetics of a previously quiet, safe neighborhood to the point of our no longer feeling safe with the additional traffic, noise, and commercial activities. We're just asking to please restore our neighborhood to comply with established law, to return the peace and quiet that we expect for ourselves, and ensure that we provide for our neighbors, to preserve the rural residential character of Hamilton Heights subdivision, to allow our property values to be restored, and to offer the best use of residential development that was promised and conveyed to each of us when home ownership was created for the Hamilton Heights subdivision. By allowing this home occupation to be approved in this small, quiet residential neighborhood, it clearly says to Josephine County residents that CCNRs no longer matter, and there's no safe place to live in this county where you can expect a reasonable degree of peace and quiet enjoyment of personal property. Therefore, we just ask that this land use home occupation not be approved. Thank you.
Thank you. And Mr. Williams, 5 minutes if you want to give us a summation.
Hi, my name's Douglas Williams, 176 Devon Drive. I just Want to say thank you for your time today. I got nothing else to say. I've opened my doors for you guys to come take a look at exactly what's going on. I got nothing to hide. It's just a one-man show. And I just do my best to, build boats for clients and make everybody happy. And I've tried to mitigate everything which way I can. And, yeah, thank you for your time.
Thank you, Mr. Williams. Thank you. All right, we'll bring this up next for discussion. This is an opportunity where the planning staff can review again the criteria, and we can have a discussion. This could include the members of this hearing board, as well as a discussion with staff, county, and any agencies that are present. I think the best way to start this would be Mr. Black. Could you approach the lectern? And I'm guessing that Commissioner Smith here has some questions as well as I do. But before we do that, is there anything that you've learned in the last month or so that you may want to share with us that you might think that we would find useful?
Good question. So the board did receive many written comments. I just want to make sure first off that you guys got those. We had at least six letters that were submitted during our open comment period. I just want to make sure you got those. Obviously, a lot of comments between about 3 parties. Between the 6 letters, it's really about 3 properties in there. Let's see. As far as the building goes, I want to be clear as far as this building goes. This building was for personal use only. That's what the permit was issued for. Anyone can build one of these shops on their property for personal use. What we're here for today is we're reviewing a home occupation to see if this proposed use can go into that shop. So that's the way we want to put it in my mind. So the building is fine, the building is there. Question is, should this use go into that building, this commercial use? That's what we're reviewing today. Yeah, it has been used as such. Keep in mind, this application also came through through our complaint department. That's how it all started as well. Typically, you have nothing happening on the property right now because they're waiting for this approval. Once they get this approval, they have a bunch of conditions they need to address. They get their ducks in a row, get their inspections done, and then they move forward. And once they get that done, they get a development permit, and then they can start operations. We're kind of a little bit backwards here. We know there's an operation that has been happening. And then we're trying to move forward with this home occupation to kind of retroactively permit that use. Things to consider as the board. Keep those in your mind. If there's questions you would like, that's kind of all I have at the moment. But if there's questions, we can generate.
Okay, Commissioner Smith, do you have any questions for staff?
Not really. I'm a little concerned about the DEQ disclosure in a couple areas. One, it says
The DEQ potential hazards checklist.
this one.
Correct. Yeah.
Okay.
That's a requirement of the kind of application.
And then second section of this, it says assessment and activities. Please circle. And number 3, it says adjacent to waterways, seasonal year round. And the applicant marked no. Again, down below, in that same section on 11, it says, will this facility activity impact stormwater runoff? And again, the application marked no.
Right. So
I visited the site.
So we all saw a drainage going through the property today. That's obvious. As the planning director, my hands are tied when it comes to drainage ways, because the drainage way needs to be classified as something. In this case, it has to be classified either as a riparian area, a class 1 or 2 stream on our county system, Fish and Wildlife. That drainage way is not categorized on either of those levels. It's not a class 2, not a class 1. The second thing we look at, is it a wetland? And in our system, we didn't find any wetlands. So that is just a natural drainage way where unfortunately I don't have, as a direct planning director, I don't have much jurisdiction on it because it doesn't fall into one of those two categories. Natural drainage ways from neighbor to neighbor. I do have Public Works here. We have a handout in our office that explains waterways and drainage are civil matters between one property owner to the next. Unfortunately, I can't get involved with those situations. That's where my limits are, if that helps with the question.
Well, the statement on the form says, will your facility activities impact stormwater runoff? It's not asking whether it's a classified riparian zone.
Mhm.
Just ask, will it affect stormwater runoff?
Yes, so stormwater there again, it's something that I don't get into because I'm held to those two categories, wetlands and riparian areas.
Apparently DEQ has it on their questionnaire for a reason.
Yeah, it's true. That's true. Questions?
I'm done with my questions.
You're done? Okay. We'll start. I've got a few different topics, so we'll start with the first one. First of all, with the noise, with a type 2 business, are there any requirements by state statute? I think it's OIR 640 that refers to noise impacts. Are there any criteria or any measurements? Is it just has to be within reason, or?
It's really, as you said,
Pretty vague.
you framed it well, within reason. Is there, my land use code does not have anything regarding noise and how we deal with that. The county code actually has a noise ordinance that falls into a nuisance category, which falls under the sheriff's office. But as far as having a business, it's really your expertise, what we can recommend as far as noise goes. Is 85 decibels too loud? Well, I don't know. We can go look at some charts and try to figure out what that looks like. That question would rely on the board to kind of decide, yes, I think a reasonable person would find that is too loud. That's kind of the argument where I would put that as far as noise goes.
Okay, and then also as far as any conditions or any requirements, any requirements in regards to visual impact?
So under a home occupation type 2, the only real visual category we see is if you're storing stuff outside. If you're storing outside materials, it must be screened from view from the abutting properties. And I believe we have that as a proposed condition in our packet for you
Okay.
in a case like that.
Hours of operation, those were spoken to earlier in regards to working normal business hours.
Board's discretion, absolutely. The code says it must operate per the hearing body's recommendation. So whatever this board decides on hours of operation.
Okay, and then I'd just like to point out one thing. There's a reference made to CC&Rs, and I think we spoke to it earlier. That's a civil issue, and that doesn't impact our decision-making process, really.
Correct. I believe county legal testified to that on the previous meeting, indicating that the CC&Rs are a civil matter.
Okay, and then the most important one, which would be the noise. I know having visited out there today, seeing that is something of, I think, significance, great significance. Should this, your recommendation move forward with the authorization of this home business, is there a way, and I don't know how this works, but I know that the, the opponent in this case right now has made efforts to have access to power so that the offending noise could be minimized or removed completely. Is it within reason to think that there could be some kind of negotiation with a condition, but not in such a way that the property owner adjacent could use that as a bargaining, a hostage, so to speak? Have you ever done anything like that before?
That would be pretty unique to do. In this situation, it would be a difficult one to do for sure. When we have agreeing parties, it's obviously much easier to do that kind of thing. Can the board make a condition that he reach out to the neighbors and obtain electrical to the building to put everything on the inside? Could you do that? Yes, you could do that. Absolutely. However, you're right, that could put a little, it gives the opportunity of the neighbors to possibly hold it up if they don't agree with it. There's the legalities about an easement. Those, how do you obtain that? I don't know if Chase, if you have any other comments on this kind of scenario? Yeah,
Okay.
it is a difficult, that would be a difficult condition to try to do. You can recommend all day. The board, for instance, the board could say, okay, business, go for it. But you highly recommend that the applicant work with those neighbors to decrease the noise issues on the property. That might be something.
Okay. I think, and this is maybe something that the commissioner and I, we can discuss, is maybe coming up with some kind of a mechanism to encourage that. I personally see that as the biggest issue out there is the noise. I live in a quiet neighborhood. I wouldn't be happy if somebody did something like this in my neighborhood as well. But at the same time, I think that it would behoove the people that are impacted to not try to work with this person, because if they didn't and this moved forward, what do they gain? It's, everybody loses. It's basically an ugly situation. I'm wondering if there is, and maybe I'm stepping outside of what the authority of this board can do, but could we continue this and see if the parties could come to some kind of an agreement on an easement and then make our decision thereafter? Does that make sense, or is that, yeah, come on up, Chase, yeah.
You can help with that? Yeah.
Because again, like I said, it looks like this is, if not more, 80% of the squabble is over. And I totally see it. I totally get it. And I'm just wondering if there's a way that we can mitigate that out completely, and that would take care of a lot of the heartburn over this.
Yes, and Chase Bagwin, County Council. Yeah, that, I believe that, first off, that's within your purview to extend this out for purposes of mediation or discussions between the parties. I would suggest that you'd probably put something in the findings of the continuance such that it's for those explicit purposes.
Okay.
But no, that's within your purview so long as the parties are consenting of that.
Commissioner Smith, what are your
Well,
thoughts?
I will tell you something that I found out recently through another constituent's problem with noise. The state has noise ordinance. They absolutely refuse to enforce because they don't have the money to do it. So that puts a burden on the county, and the sheriff won't do it because he doesn't have the staff to do it. So we're in a catch-22. When it comes to noise, it's going to be totally up to the person making the noise. Now, I worked on aluminum. I built a lot of aluminum signs and aluminum frameworks through my career. And when you start working on them, they make a lot of noise. When you grind on that or hammer on that, that makes a lot of noise. I know, because I have to wear hearing aids because of that. When you saw that stuff, it gets a tremendous amount of noise. So I don't know how you're going to mitigate this noise and get any kind of enforcement out of it, because the state's not even enforcing their own ordinances. So here we are. In the catch-22, you want to set up something to mitigate noise? The state's not going to help you.
Exactly.
The county's not going to help you. So where are you going to get your help?
And that's where it kind of comes down to where it may be, and again, I'm not giving legal advice to the other parties here, it may behoove them to come to some form of a settlement, because like you said, we don't really, the county doesn't have parameters. We don't have anything in our code. The state isn't enforcing that. In my personal practice, the way that we've dealt with that is through civil litigation. You know, we've had people had to hire attorneys and come to some form of a settlement agreement on those bases. So typically in those kinds of instances, that's what you're dealing with is two parties have to come to some form of a settlement or contract between the parties to mitigate it under certain parameters. What that looks like obviously differs depending on the person, but you're correct. We are kind of, our hands are somewhat tied when it comes to decibel readings.
Right, and
Never done that.
yeah. In this instance right here, and I understand working with aluminum because I've done that myself, is that the generator is to me, it's the constant 8 hours a day. It's just right, and it's running all day long. If that could be taken out of the equation, of course, there's going to be hammering and there's going to be throwing and there's going to be bending and there's going to be that kind of noise. But you know, no noise is good noise, but less noise is more tolerable than more noise. And so I would like to see another continuation on this with hopes that the two parties that are involved here could come to some kind of agreement, and that would take a lot of the anxiety over what's going on here out, I think.
Yeah, and I think it would limit what you guys have to adjudicate because right now, like James was kind of explaining, making a finding in any direction without like very detailed findings is going to be kind of difficult because we're dealing with such layers of issues here. If they were to be able to resolve that, I think it would help streamline the adjudication in this matter, if that makes sense.
So what do you do when somebody violates that agreement?
For the county's purposes, you would have no interaction. If they violate the agreement, they'd hire an attorney and sue the person for
So we're right back where we started.
pretty much.
I would like to give it an opportunity, but so thank you for that, counsel. Ms. McCarty, could I ask you to come up to the lectern? And I'm guessing this is probably something new to all of us. Maybe you have thought about this to some degree, but would you be open? Because I understand it's your property that would require the easement across your driveway so that Mr. Williams could get away from that generator running all the time. Is this something that's within the realm of possibility that you would entertain and negotiate and work something out, or is this outside of what you're willing to do to help the situation?
Andy McCarty, 160 Devon Drive. So yes, I appreciate that you are asking these questions, and we have certainly talked about this and with the Tedson and our neighbors. And I mean, correct me if I'm wrong, but I would say that the generator is, you're right, it's like all day, but that's a portion of it. The other noise, it's that clanky to the banging and the shh and the all these other noises that what happens to that? And we haven't been able to figure out what the enforcement is to stop that, because the guidelines say it should just be normal, you know, not go beyond normal. I don't have my paper in front of me, normal perception at the property line. And it clearly does. It goes beyond property lines. So as someone who loves to mediate, and I do love to work together, I feel that I don't see how this could be, I don't think that that would solve the problem. I really believe in my heart of hearts, granting an easement for Mr. Williams to have power across the McCarty driveway would not solve the big picture. Is that correct?
Okay, and again, I think we're not looking to solve all of the challenges that are in front of us. We're trying to solve the big ones so that they don't become issues in the future. If I could tag on to that, and I know Mr. Williams' shop is not insulated. If he were conditioned to work inside and insulate his building so that the noise wouldn't propagate, would that be something you'd be open to?
So I can tell you that, I mean, definitely that sounds like that would be helpful. I don't know that that will, I guess my question to you is, would it be acceptable to go to another location for the boat shop, like where it used to live? Like that could be a win-win for everyone because he's been successful, he is successful in an industrial zoned location. Coming into our, I mean, what if, you know, do you see what I'm trying to say?
Yeah, I totally understand what you're saying, but at the same time, in our code, there's allowance for type 2 types of home businesses. And we know that some home businesses have very, very minimal impact on the neighborhood and others have more so. In this instance, it appears that it has more than what you're willing to find acceptable. And so, you know, we have the code, we are given recommendations by our staff, and sure, we have some in the decision-making process here, but it's not a win-lose, it's everybody loses, unfortunately, in these types of things. It's just, can we be as impartial but yet be following the code as possible? So it's difficult. So I guess what I'm trying to say is we encourage business here in Josephine County. We want people to have businesses. We want them to bring traded sector dollars into the county. We need that. We desperately need that. But at the same time, we also understand there are going to be impacts with those changes. So trying to preempt any civil recourse, litigation, all that, I'm just trying to see if we can kind of horse trade, so to speak, and get kind of to a place where everybody's unhappy the same amount, I guess. You know what I mean? It's just one of those things. If you would be open to the easement and doing other noise mitigation conditions, do you think we could move forward to something maybe? And I'm asking you only now. Once you're done, I'm going to ask Mr. Williams the same questions because there's a cost incurred on him. It's not just that he can wave a wand and his shop gets insulated, and to pull in the power is quite expensive. That's going to be quite a burden on him. And so I'm going to ask him his thoughts, but do you have anything else that you'd like to add?
I guess I would just go back to, and I appreciate you explaining that a little deeper for me because I don't do this. And so this has been a huge learning process. I would say that in looking at the code and the requirements in my own little brain, I would feel that if we don't meet those requirements, then it should not be allowed to continue. And so I would just say that I'm sorry, we're not open to an easement at this time. We are not open to an easement. We just don't believe that this type of home occupation fits the neighborhood. And I appreciate you saying that we do love business and we have allowances for home occupations because our world has changed so much over the last several years. But I feel that home occupations should still kind of fit that neighborhood requirement. So maybe if we all had 40 acres and we never heard or saw anything, that could be a different scenario. But I feel we're so close to each other, it really does impact us. And so that's what I would like to say.
Okay, I would just like to remind you that if this board allows this use as presented by our staff, you get what you get. Okay, there's a risk.
I understand that, sir.
Okay.
Yes. And just in my heart of hearts, I know that what you saw today and you realize that our neighborhood is not fit for that large occupation. And we have lots of opportunities in Josephine County for that business to be successful and still bring money to Josephine County, just maybe not at 1767 Devon. It could just be a personal shop, and then he could make his boats at an industrial complex. And I see another real estate agent in the audience, so I'm sure he would help him find a spot if that would be helpful. But so, thank you.
Okay, thank you for your input. Looks like my effort to try to negotiate something is not going the direction that I had hoped, but Mr. Williams, would you like to respond to that in any way? Maybe you have some ideas. Just some thoughts.
Like I said, I'm Douglas, 176 Devon Drive. This is what we've been fighting since day one, is approval for to get power to the shop, to mitigate all sound. The doors being closed and the shop being insulated would be a huge advantage. And the sound that the generator makes is most of the concern here. The work that goes on inside that shop, it's not like I'm grinding all day, every day. That'd be crazy. I'm not using the saw all day, every day. That would drive me nuts. It's only for just a small portion of the day that I would use the saw or grind or weld. You can't hear welding. It's so quiet. And most of it is welding. Welding on a boat, you got 25 feet of weld on just one weld. You got miles of welding to do on the boat. That is majority of the building process is welding and rigging the boat as well. It's not like I'm making all kinds of sound when I'm putting the boat together for its final process. And that process takes longer than actually building the boat itself. So it's very minimal that I'm making noise that's a nuisance in that shop. It's the generator that is actually making the sound. And I only use the generator when I need to turn on my welder. And when I turn the generator on, the whole facility is powered up. That's why it runs at high RPM with 74 decibels. And it would all be mitigated if I had power. We all go to work during the day. I never work before 8, and I never work past 3. I have to go pick up the kids. At 1:30 is when I go pick up the kids, and I'm back around 3. And I'm getting them set up. I'm taking care of them while the wife is working her full 8-hour day. And going back to the morning, I help out, get the kids ready in the morning. So I'm never at the shop before 8 o'clock. It's always after 8 o'clock. And so you're talking maybe 5 to 6 hours a day is all I work. And most of the sound is mitigated, would be mitigated if I had power. So.
Okay, thank you, Mr. Williams. Staff, do you have any comments before we close the record?
Before you close the record, when you start moving towards your motions, just want to let you know to allow us to help you with that.
We will.
It's going to be
We will.
Yeah. It's going to be a little different motion than what this board's used to in other types of land use procedures. So.
Okay, thank you for that. All right, then with that, if Commissioner Smith, if you're okay with it, I'll go ahead and close the record. Unless you want to have any
No,
questions.
I think it's been discussed thoroughly. Yeah, you can close the record.
All right, then right now at 2:53, we'll close the record. And this will give us an opportunity, Commissioner Smith and I, to deliberate and come hopefully to a decision. And if you'd like to start off.
Well, I can understand. I live on a cul-de-sac. And I would not want my neighbor to do what you're doing in my neighborhood. Simply because I believe you have a right to peaceful enjoyment of your property. In fact, that's part of the code. You have a right to peaceful enjoyment of your property. And when you live in a rural area like that, you didn't go there to hear a bunch of noise. You didn't go there to have somebody build airplanes, boats, cars, anything next door to you. You wouldn't want somebody having a sawmill next door to you. You're in a residential area. It might be completely different if you're on 5-acre lots. We're talking about 1-acre lots. And that's pretty close proximity. So I mean, I live in the cul-de-sac, and I personally not want somebody starting a business right next door to my house. And I can understand your concern. I think also there's an element there that it will devalue property rights. Because when you go to sell your house and they say, well, we have litigation with the neighbor next door, Well, I'm going someplace else. Simply because they don't want to move into a neighborhood that has problems like that. So I can understand their point. And I'm a little concerned about the misrepresentation on the DQ form. I don't know if you have this one, Commissioner.
Yeah, I do. It's in the packet. Yes.
But I'm a little concerned that the stormwater runoff and the seasonal creek was addressed as no, no. And obviously after visiting, it's a yes, yes. Even though it's not classified as a riparian area, obviously when it rains, there's quite a bit of runoff in that. And I could see already standing water at the shop location today. And so I don't know. I think your shop's going to get flooded because of where it's located at. There's a lot of water coming down that hill at certain times of the year. So I have some concerns about it.
Okay. I would like to speak to a couple of items. The points being contested, there's 6 points that you have that are being contested, and some of them are pretty straightforward, like the location of the drain field for the septic, outdoor hazardous activities and hazardous material. The third one, which is the noise that we've been talking about, and if this were to move forward with a motion to approve, I would be interested in some kind of mitigation or something to minimize the noise impacts. The drainage issues are certainly ones for whatever is constructed there. That's their responsibility. But as far as any requirements are concerned, there's no erosion control requirements that I can tell, and from the staff report here. The hours of operation are certainly a concern, 8 to 5, Monday through Friday, and there's no, I think there should be a condition to prevent work on major holidays. I think Mr. Williams here has stated he's a family person, has got kids. I doubt he's going to be working on holidays. He's going to be spending time with his kids. The CCRs, which is the last item on that points of contention, that's a civil matter. That doesn't involve the county. So again, like I stated earlier, my biggest concern here is the noise. I've made an attempt to try to get the parties to agree to something to obviously not zero out the noise, but to minimize it as much as possible. But it appears that there's no possibility that that's going to happen. So any comments on my comment?
The noise is a problem. I think the noise is a serious problem. And I, like I said, I would not want some neighbor of mine starting a business next door to me. Because I like to sit outside in the summer on a warm summer night. And I want to hear the birds sing. I want to have the peace and quiet. I don't want to hear a bunch of noise banging on aluminum and stuff like that. So that is a problem. And I know how I know, unless you put air conditioning in a shop in the summer, that main door is going to be open because it's going to get hot in there. I've worked in a metal shop. Without air conditioning, even a very, very well insulated shop, without air conditioning, it gets very hot in the summertime. So that door would have to be open. So I don't know how you're going to mitigate the noise problem. I mean, I've worked on aluminum. I've beat on aluminum. When you run a saw and you cut a long cut on a piece of sheet aluminum, it's noisy, very noisy. Something I don't know if you could probably hear it outside the shop, even though it was fully insulated. I know I worked at a fully insulated shop, and I've sat outside and listened to the saw run. It's quite loud. So I don't know how you mitigate the noise, especially when you got a state that will not do anything about noise, and we don't have any remedy, even in our county, to mitigate noise. What do you do with it? So you're going to end up with another civil matter. So you make an agreement, and one guy violates that, then what's your choice? Take them to law. And then what do? The state won't enforce it. I imagine that'd be quite a hairy situation. If you made agreement and he just violated it, what's your recourse? I have a problem with that.
Okay, I'm not disagreeing with anything that you're saying there, Commissioner Smith. I would just like to reiterate what I said earlier. Josephine County encourages home businesses. We like to see home businesses bring in especially traded sector dollars into the community. That's a big thing. Home businesses are also fantastic because it keeps the wage earner or the employer home with their family, and that's important that the families are together as much time as possible. Unfortunately, this has put us in a position where the decision is lose-lose.
No,
It's,
I
it's,
don't disagree with anything said. I appreciate people to be able to carry on their business at home. It's very difficult when you have a business that makes noise and you're on a 1 acre lot. If you're on a 5 acre lot and you could mitigate this by setbacks, you could probably solve a lot of your problem. But a 1 acre lot, in that little draw, the way that, the lay of the land is there, you're gonna hear a noise. Quiet summer night, you're gonna hear a lot of noise. I don't know how you mitigate that. It is a serious problem. And I'm concerned about what's gonna happen with the runoff here because somebody's gonna get flooded downstream.
okay, thank you for that. Chase, can I get you to come up to the lectern? So we're going to ask you a question. So I think that we have a scenario here where we don't have a majority in the direction that we want to go. So it appears to me that we have one commissioner wanting to go one direction and another one interested in going another direction. We don't have our third commissioner here because he's recused himself because of his connection to one of the parties. And so should I go ahead and ask for a motion and go through the whole process? Or,
Somewhat up to the commissioners in this regard. What I would suggest at this time, again, depending on what your personal beliefs and where you're at kind of process here, there's always the opportunity to do a brief extension for further deliberation of the commissioners. If you guys could think of something that would kind of play in the middle. If you know that you guys are going to maintain different policies, then yeah, you would go to a tiebreaker, and then I would be discussing with James as to what the next steps of that would be. But for purposes of this hearing, it would effectively be a non-decision for the day.
okay, so as far as the ORSs are concerned, if Commissioner Barnett has recused himself, he could not be brought back into this in any way, right? Okay, so if there was a tiebreaker, the tiebreaker then would go to community development?
I believe so. I want to double check the code. I think there also may be a parameter whereby you guys, and I think Chris would be precluded from this as well, but where you bring in an interim third for this specific tiebreaker. I'd have to look to the code specifically to what details that, or if there's underarching themes of that. But for purposes of today, it will just end in a tiebreaker.
Okay, so should we go through should we go through the motions of having Commissioner Smith make a motion and all that? Okay, all right, we'll do that.
Question.
Yes.
So in this motion, it's approving the appeal.
Yes.
So we're ready for a motion?
Yeah, so to be clear, okay, we'll go ahead and make your motion and I'll ask for clarification.
I'll make a motion that we approve the appeal on this land use issue by McCarthy's and approve their appeal.
Okay, so just for clarification, this motion to approve the appeal will not allow the approval of the land use application as was approved. Okay, then I will say that motion dies of a second. Would you like to make another motion?
No.
Okay, so we're at a stalemate here. Then we will go ahead and close the hearing, I guess. There's nothing else we can do right now, right? Or is there? Continuation? Okay. Okay. Okay, yeah. Okay, so then what we will do is, do we need to do that through a formal motion or just state it? Yeah, absolutely. If you want to take like, what, a 3-minute recess? Yeah. Okay, yeah, absolutely. So we'll take a recess right now from 3:04 to say 3:09, 5 minutes. Okay, you bet. Couple minutes earlier than we said. I believe everybody's here in the building, so let's go ahead. Yeah, thank you, Mr. Council.
Jace Bagwin, County Council. I did have a brief speech with Mr. Black. This is kind of a novel situation because in the county, we haven't really had a true split very many times. So for purposes of this one, to clarify myself, the vote to approve and the vote to deny means that the appeal just dies at that stage because there's a non-decision at that stage. So at that point, I believe Mr. Williams would have the opportunity to bring the next step up to LUBA if that was the opportunity. But for purposes of today, it would just be a non-action and the appeal would die.
Okay, so in terms of process, this is a non-action and we will close this out completely and there will be findings and staff will prepare the findings.
Correct.
Okay, and then those findings then will give the opportunity to Mr. Williams to take that to LUBA, Land Use Board of Appeals.
Exactly.
Should he
And he
choose
would
to.
have some more flexibility if we weren't as close to the 150-day timeline, but at this stage, he can't even grant us an extension for further deliberation. So we're kind of stuck with what we have today.
Okay, all right, thank you for that. All right, then in that case, we will, just to be clear, the appeal dies. And because we have a non-action today, and we will close the hearing with that. All right, it is 3:08 and we will close this hearing. Thank you, everyone.